This meeting of the House of Justice Civil Subcommittee will come to order. Members will indicate their presence on the electronic voting board. Madam Clerk, the clerk will, Karen? The clerk will close the roll. And it appears that we have not only a quorum, but perfect attendance here on this first day.
Oh, like the first day of
Civil
school.
Sub, the first day of school.
The last time. Won't last long.
All right, so we only have a few bills on the agenda. I have a couple of bills where the patrons have asked, as I mentioned this on the floor today, to go by for the day. As a rule, we're going to try not to do that. This is a short session. We don't have a ton of meetings. So you may, this is just a word to the wise out there. I know there's a lot of advocates and other patrons. We may give you one, maybe early in the session, but there's no guarantee if we take it by for the day that it will ever come back. So just beware if you want to do that. That said, I think we'll be okay with Chairman Watts's HB 1721. Also, I told Delegate Converse-Fowler her HB 1690 could go by for the day. Can I get a motion to take those two bills by for the day?
So moved. Second.
It's been moved and properly seconded. Those bills go by for the day. As many as favor that motion will say aye.
Aye.
Those opposed? All right, those bills are by for the day. First bill we've got up is, we have a patron for it, is Delegate Ballard. Delegate Ballard, you want to present from wherever you'd like? It's fine with me.
Thank you, Mr. Chairman. I'll present from here if that's acceptable.
Okay, and that's HB 1584 for those following along at home.
Thank you, Mr. Chairman. So I do have, as noted, HB 1584. It's dealing with Code Section 8.01-126. As a preliminary matter, I do just want to thank the Poverty Law Center for a really good conversation we had about an hour ago, so I could kind of just think this through with them. So thanks to Christy and Janae. The intent of this bill is not really to change this area of the law or this code section that significantly. All I'm trying to do is once the writ of possession is granted by the court, I want to eliminate that 72-hour waiting period that you find kind of halfway through that code section. So this is not dealing with, it's not the intent to disrupt the appeal period. So as you all probably know, once you file the unlawful detainer, you go to court. My understanding is, after talking with Ms. Olwine, that's when the 10-day appeals period runs. Then you would go back to court, get a writ of possession, then you're dealing with this 72-hour waiting period. So I'm not trying to disrupt appellate rights or any of those things. I think we may have some differing of opinion with the Poverty Law Center folks and even I when I talked through this with them about how it works. But it's pretty simple in its form. I'm just trying to eliminate the situation where once you are granted that writ of possession, you then have to wait 72 hours to actually get back into the single family dwelling. That's all it deals with. So pending any questions, I may have some, and maybe Ms. Olwine can explain it better than I can, because I think there are some differing opinions on how the bill is drafted. Thank you, Mr. Chairman.
So, Delegate Ballard, just a quick question. I can just go to you or to Ms. Olwine. I think either one is fine. But I just want to be clear. This is a expedited process that we've already established for those situations where there is no rental agreement, and it's proven there that by, I think, by whatever the standard is, that there's never been a rental agreement. And so we're trying to get after, or we'll call squatters, I guess, right? And I've seen some of these things on 2020 and other places where there's a movement where folks will move into a property, order an Amazon package delivered to that property, and then start showing folks, look, I've got an address that says I live here, and just sit down and then go through a sort of prolonged eviction process where they get to live rent-free, which that's, I think, what we're trying to do. We did some work with Delegate Leftwich's bill last year, which went through general laws, actually, to expedite the docketing of those, get them heard faster and so forth. And what your bill, I think you're saying what you'd like your bill to do is in those, only in those situations, once those other elements have been proven and established, that when the eviction process comes, they don't get the same sort of 72-hour notice that the sheriff's going to be back to take your stuff out that they get, that an actual tenant would get. That's what your intent is.
Yes, Mr. Chairman, great explanation. That's exactly right. It's dealing with a situation where there has never been an agreement. Usually these people have never met, completely unknown. So it's not like a holdover tenant situation or there's some disagreement over how long they're supposed to be there. It is, there has never been an agreement, your traditional squatter situation. And certainly I would defer to Ms. Olwine if she can explain it better than I can. But I think it's pretty simple in its concept. As written, it may not be as clear as it could be, but I'll let Britt.
All right. Yeah, anything to add at this point?
No, Mr. Chair, Delegate Ballard summed it up well. We did add the language in subsection 1 of this section last year through Delegate Lethbridge's bill. I will say that the 10-day appeal period of 801-129 is not touched by this. If we need to tighten it up to make clear that that's the case. But the last sentence of subsection B says, in no case, however, shall the sheriff evict the defendant from the dwelling unit prior to the expiration of the defendant's 10-day appeal period. And that's not touched in this bill. So if we need to clean it up, we can, but the way that I would read this, it really waives the 72-hour notice period and not the 10-day appeal period.
All right. Delegate Reeser.
Thank you, Mr. Chair. Mr. Chair, Detective. Delegate Ballard, sorry.
Are you cross-examining?
Yes. I just want to understand, what about in the instance where there is an agreement, but it's just oral?
This would not cover that situation. There has never been an agreement. And so that's part of the evidence that they would submit during the unlawful detainer process. So there is a court process. You have a hearing, judge hears the evidence, right? And so let's say they go, okay, yes, I agree with you, plaintiff, homeowner. Then you move to the next phase, which is the writ of possession. So it doesn't deal with your situation, I'm not trying to touch that. It's just on that second phase of it where typically you had to wait the 72 hours. I'm saying that can be waived. That's all we're saying. But to answer your question directly, Delegate, there has never been an agreement, not even an oral agreement.
All right, Delegate Sullivan.
Thank you, Mr. Chairman. Question for either the patron or counsel. Line 41, where it talks about the 72 hours notice of intent requirement, you may request that it be waived. Do we need to give the court any instruction about the circumstances which would entitle this case will get waived, that case won't? Or is that implied in here somehow?
Well, Mr. Chairman, Delegate Sullivan, I mean, I certainly think we could add something like that, but I think it's just a simple request to the court. Typically, you would have that 72-hour waiting period, and then this would just say, Your Honor, I requested that be waived. And I don't think then you would have to present evidence of any set of circumstances that the court would have to factor in to grant that. It's just, sure, I grant it, or no, I don't.
Mr. Chair, Delegate Sullivan, I would agree with that, and this would just give the court discretion to grant it or not. So the court could say, we're still going to do the 72 hours.
Thank you, Mr. Chair.
And thank you. And counsel, I think now that Delegate Sullivan's raised this, it also looks like it says, and request the sheriff immediately. So it's not even an order to the sheriff. So either the judge or the sheriff could say, request received, no. I'm not going to do business that way, it sounds like.
Mr. Chairman, I think that's right, the way it's worded.
Okay. All right, Delegate Keith-Gamarra.
Yes, I actually have a two-part question, Mr. Chair.
I'll allow it.
Thank you. I'd like to follow up on Delegate Reeser's question with respect to whether it was oral or not. Will those folks who may be the subject of this litigation be represented by counsel?
Well, Mr. Chairman, to the delegate's question, I assume they could request someone like through the Poverty Law Center to represent them. I mean, they would have the opportunity to have counsel. Whether or not they qualify for counsel or they have to retain counsel, different question. And certainly I welcome Poverty Law Center input on that, but they would have the opportunity to have counsel for sure.
Let's hear part two before we call anybody else up.
Part two is there language specific in this bill, and I'm sorry I didn't have a chance to review it since the question was asked, that would cover how it would be handled if it was an oral agreement?
Mr. Chairman, to the delegate's question, my bill doesn't change any of those court procedures. All we're doing is on the back end of it, the writ of possession action part of it, we're just saying 72 hours can be waived at the discretion of the court. Nothing else with the court process would change, the way you present evidence, counsel, any of those things. That does not change under this bill. It's just the 72-hour period may be waived. That's really all it does.
I think, talk about it, and then we'll call on the public here for a second. Just, I think the concern I hear, maybe it's my own concern, not hers, I'll just say it this way. A lot of times, a lot of these defendants are pro se, or they are of limited means, and so, somebody gets a summons to appear in court, it goes through this very expedited process. They don't show up for court that day at all, right? They never get a chance to assert even that there was an oral agreement or anything. The process starts steamrolling. The first time they really start paying attention would be when that sheriff sticks something to their door. Says, hey, your stuff's about to be taken out. And now they're actually like tuned in and or realize the gravity of it, or that it needs to be the priority over whatever else is going on in their lives. And they don't even get that 3 days to sort of brace themselves. I think so for what it's worth. I don't know if that's a question or a comment or just me kind of going on and on. But at any rate, let's hear, is there anybody in the audience who wishes to speak in favor or against? We don't need to go in order necessarily. Why don't you guys come on up and weigh in on the bill? A quick question, and maybe you don't know the answer, somebody else can answer this, but the sequence, does the sheriff have to wait until that 10-day period is over, then they tack it? So essentially, I think what is in other words, talking about, are you trying to get from a 13-day waiting period to a 10-day waiting period by being able to do this? Is that what this would accomplish? Or can you do them concurrently?
You can do them simultaneously. Again, under 8.01.129, under 8.01.129, the court can issue that immediate writ of possession, but you still get the 72-hour notice. You still have to wait 10 days. That you still can get a 10-day period afterwards today. So it's not 13 days. It can still be 10 days today.
Mr. Chair.
Delegate Sullivan.
So, ma'am, do I understand your testimony to essentially be that you don't think this will change anything?
All right, thank you. Actually support. Believe it or not.
This bill, it is kind of a tweak to a bill that passed last year, and I think it's important to point out this bill is a separate code provision from landlord tenant in that it only deals with squatters, and the way that that was defined was they do not have and have never had a rental agreement, and in writing that, we chose definitely to include oral agreements as well. I apologize that I don't have the language right in front of me, but it's my understanding that they
Counsel.
So when I read through this bill, my thought was it's a writ of eviction, the 72 hours, the 10-day period should have already passed. So nobody's losing their right of eviction. That was my understanding.
All right. So I'm going to make sure. So today is the 13th of January. I'm in court today. I get a writ of possession, right? 10 days. So on January 23rd, the appeal period is gone. I go back to court to get a writ of eviction, or okay. So I go back on that to get the writ of eviction. That's issued under current law. The sheriff then has to post something on the door and say, hey, within 72 hours, we're going to be evicting you. Under Delegate Ballard's bill on the 23rd or the 24th, they can show up with the moving trucks and the equipment and all the stuff and physically remove people from the property. Without your bill, they'd have to wait another 72 hours to the 26th or 27th. Am I understanding it right?
You are spot on, Mr. Chairman.
Okay, so this does do something. It doesn't do something. Again, at that point, the time they see what I'm hearing is, by the time they see the thing stamped on their door, it's too late anyway to do anything about it. So the fact that they see it or not doesn't really do them much time to do anything other than maybe pack, right? So, okay.
Mr. Chairman?
Yeah, Delegate Thomas.
I have a question for council. This is not my area of expertise. So before this gets posted on the door, how many opportunities for notice has this person had? I mean, if we're using the example of the squatter, I'm sure they've had some type of required legal notice under the code like we do for service of process. But before this gets posted, how many opportunities has the court required someone to demonstrate they tried to find this person? Thank you, counsel.
They would also get served with the notice of the hearing. Yeah. So that would be written notice to vacate in this formal service of process. Just offered last year's bill. If someone comes in and said, the landlord is obviously going to serve, there's been no lease. Tenant comes in and says, we have an oral agreement. Decision, I would suspect, based on our practice, that if someone asserts there's been an oral agreement, that's going to throw this into another realm.
All right. Is there anybody else wishing to be heard on this bill? Any further discussion from members of the subcommittee? All right, are the members of the subcommittee ready to vote? Committee operates by motion. Oh, wait, Delegate Keys-Gamarra.
I did, because initially Mr. Chair, initially we started saying that this really didn't change in terms of the right of appeal, but does it change in terms of their legal status, having had that writ issued? If council could answer. I mean, when I think about the affordable housing context, right, and the fact that they're not represented by council, I get a little concerned, and so I think this additional step has to represent something in the legal process. And what is that? In terms of their status.
Sorry, is your microphone on? I'm hearing that it's not being picked up outside of the room.
Not,
Way to click.
it's on. Is it? Okay, so
All
maybe
right,
it's
if you guys
just,
can lean into your microphones.
I'm leaning
Of course,
away.
it's hard to
Okay.
hear on. You're not here in the room, we can hear you fine, but apparently people.
Okay, okay.
So Delegate Kizumara, if we get to this point in the code section, I think their legal status would be there was never a rental agreement that existed, and they're not legally entitled to be on the property. So again, colloquially, I think we would say that they were a squatter. I don't think that anything would change in the sense that at no point, if the hearing has happened, at no point would they be adjudicated a tenant and have any sort of tenant rights that would exist under the VRLTA, except for we do have the other 72-hour notice requirement for the eviction, which tracks from 801-129. But I don't think that their legal status would necessarily change given the fact that they would have probably already been considered, quote unquote, a squatter.
All right. All right. Not seeing any further questions. Is there?
Mr. Chair, I did have, so maybe this is for Ms. Elwin or the patron. So the section itself is directed at squatters. But if someone who's living in the home wants to try to convince a court that they're not a squatter, that they actually have or someone gave them permission to be there, they have some sort of lease, we're not doing away with that right.
Mr. Chair, Delegate Sullivan, no. There would still have to be a hearing, and evidence would have to be put into the record for them to be adjudicated a squatter. So if they wanted to prove themselves to be a tenant, they could present evidence that they have an agreement. Here's the lease. Maybe there's text messages if it was an oral agreement and stuff like that. So that wouldn't
If they come to court and lost that argument, or if they've declined the opportunity to come to court and make that argument, 10 days out from that hearing, or whenever it takes place, this would allow the court, if it wanted to order them to leave that day rather than 3 days later. Is that right?
Mr. Chairman, Delegate Sullivan, that's correct.
Thank you.
That's correct.
Well, all right, hold on. Ms. Murray shaking her head no. She doesn't think it means that. Going up to the microphone, please speak into the microphone.
Thank you, Christy Mayer, Virginia Poverty Law Center. I believe that eliminating this 72-hour notice requirement doesn't expedite anything, because under 8.01-129, you already have you have the opportunity to get an immediate writ of eviction, which you would get at the hearing when the judgment for possession is entered. And then you can send that to the sheriff. That actually orders the sheriff to execute the eviction. And then the sheriff is still supposed to give the 72-hour notice. But in any event, that eviction cannot be executed until 10 days have passed. So even if you eliminate that 72-hour notice from the sheriff, I believe there would still be that 10-day waiting period. So I don't think it actually changes or expedites or slows anything down.
Chair.
Delegate Sullivan.
So I'd understood in response to the question I just asked that, I think the chairman asked this earlier, that the way it works now, you get 13 days from the hearing. If you read the two statutes together, you'll end up with 13. You've been declared to be a squatter, and you get 13 days to stay.
So
This would do, at least potentially, if a court allowed it, would reduce it to 10 days to stay after you've been adjudicated a squatter.
And Mr. Chairman, Delegate Sullivan, it's my reading of this statute that you all are looking at amending in conjunction with 8.01-129, that even under current law, without this change, you can still get the eviction executed within,
On the 10th.
on the 11th day, essentially, I believe.
Yes, Mr. Chair, Delegate Sullivan. So if you look at 801-129, subsection B, the first sentence says, in any unlawful detainer case filed under 801-126, and then it goes on, it talks about the 72-hour period, the 10-day appeal period. The section that we're looking at that Delegate Ballard's trying to amend is 801-126, so the 10-day appeal period is gonna track for every single thing in this, including the squatter hearing, if that makes sense.
I could beat a dead horse here for a second. I get that the 10-day period's not touched. What I don't understand is why this isn't a 13-day period that we're taking to a 10-day period. Nobody's explained to me what there isn't something that's being truncated here. Does somebody want to give it a try? Because I'm
going to try.
Okay.
I'm Erin Corman with the Realtors. The way it was just explained to me is that, yes, they can wait till the 10th day to give the notice, and then it would be 72 hours, but they can also file the notice on the 7th day. And then they would still have 72 hours. You would still have your 10-day appeal period. But effectively, then you could. So there's a maximum of 13 days we're dealing with here. But the minimum amount is 10.
You already have a process. If you're actually really sharp in the way you practice, you'd do it on the 7th day anyway, and instead of waiting to.
Well, and you'd have to have the sheriff on your side, but correct.
But again, even this language we established earlier, this is a request to the sheriff, not an order to the sheriff. So there's the two arguments. One argument would be that this doesn't do anything. The other one would be that it does too much. It could suffer from both possible maladies here. Sorry about that. Anyway, all right. All right. So again, I think we're ready for a motion. It's been moved to report. Is there a second? Second. All right. It's been moved and seconded to the bill report. Is there any substitute motions? If not, the clerk will open the roll. All right, and the bill reports 6-2. Be there at full committee, Delegate Ballard.
Yes, sir.
All right. Delegate Carlson. Thank you for joining us over from Crim Sub. We will try and get you back there as quick as we can. You've got bill number HB 1605 to the Uniform Trust Code.
Thank you, Chair Simon. I'm trying to remember if I need to press anything, but no, y'all can hear me. So this is a technical fix that allows more qualified entities to serve as trustees of self-settled spendthrift trust. There's an expert here who, Catherine Ramsey, who's a partner at Virginia Estate and Trust Law. With a name like that, you know she knows this stuff. It is coming out of the Boyd Graves. Am I saying that in the right order? It's been a few months since I've been here. Boyd Graves' recommendation. In short, there is a definition of a qualified trustee and an independent qualified trustee. This is basically a Scribner's error that occurred that I guess they're changing to make it so that charitable organizations, other qualified trustees can serve in those roles for those types of trusts. And with that, if there are any questions, I do have Catherine Ramsey here.
I do see some people shaking their head no on the Boyd Graves assertion here. So I think that there's been a group of very esteemed, smart lawyers who've looked at this, but they just a different group, not Boyd Graves. Am I understanding y'all correctly? All right.
My apologies.
It's the Virginia State Bar, Virginia Bar Association. God, not the VSB, but the VBA. All right. Are there any questions from members of the subcommittee for Delegate Carlson about this bill? All right. Is there anybody who's likely to vote no on this bill? All right. Seeing none, are we ready for a motion? Or do you really want to talk about it? It's up to you guys. No. All right. It's been moved and seconded to the bill report. The clerk will open the roll. Oh, she's catching up. We went a little too fast. All right, the clerk will close the roll. The bill reports 8-0. You don't need to come to full committee, but I think you'll be there anyway.
Thank you.
Thank you, Delegate Carlson. All right, we are waiting on Delegate Delaney. Can you send Delegate Delaney over when you, Delegate Carlson?
Oh, she's over in Crim?
Yeah, she's in Crim. Hey, Delegate Carlson, if you can tell Delegate Delaney to come on over, that would be much appreciated. Thank you. All right, with that, the committee will be at ease. Don't go far.
to the victim. Causation. That's causation, right? But for. Why did we create that? Because these things are happening where there are vulnerable victims. These people pick these jobs to get access to these victims. That's why you see them in nursing homes, in hospitals, at massage parlors. The people who do these things seek out those jobs. And if you own those kind of companies, you know, the burden's on you to mitigate against that risk. That's the first part, causation. The second part says it just has to be on the employer's property, on property where they were sent to, like you send someone to give home health at their house, or in a work vehicle. But again, all we're asking is that the jury decides. And that's where we get to part B. These issues are going to be decided by the jury. Consistent with the U.S. Constitution, consistent with the Virginia Constitution, the jury needs to decide. But even if they get all of that, again, not strict liability. We're not saying that you must hold them responsible. We're just saying that that's where you can find course and scope. Still have to prove the tort. Still have to prove causation, damages, all the other things. We're creating a door where one has been shut. And we hope that it'll be the pleasure of the subcommittee to pass this legislation.
Mr. Dix.
Yes.
Quick question for you. So were these, this trilogy of decisions, this was all authored by one particular justice on the Supreme Court, is that right? Or was it from a number of different folks?
Mr. Chairman, that is correct. All three decisions were authored by Arthur Kelsey on the Supreme Court. When you read the very first decision in the trilogy, Parker versus Carillion, he stated in no uncertain terms he wanted to roll back the law. He relied upon 11 decisions issued between 1917 and 1960. He stated that because of doctrinal vagaries, it was holding to the belief first expressed over a century ago that the only safe course to pursue is to revert to first principles and adhere to ancient landmarks rather than yielding to some new principles sought to be engrafted upon the law. Now, if that doesn't sound like I'm taking things back to the early 1900s, I don't know what does. He then quoted Justice Oliver Wendell Holmes, who notoriously was a critic of vicarious liability. He didn't believe companies should ever be held responsible for anything. And then he quoted a legal scholar, this is in the first opinion again, Parker versus Carillion. He quoted a legal scholar who said, you know, in most cases, an employee's intentional torts are purely personal acts and thus not within the scope of employment. And then in his second and third decisions, he cites to himself. So he does the first decision, and then he says in the second and third decision issued a year later, look at my earlier opinions. I mean, I pull that on my kids, but, you know, but it is completely rolled back, and I'm sorry to be humorous, but he's completely rolled back the law, and there is now no civil remedy for the victims of these acts.
Gotcha. So, Mr. Again, just Dave Albo here. I'm calling Albo, but yeah, I'm like a regular guy here. I just want to understand, right? So, somebody, a nurse, an orderly, or whatever, commits a sexual assault at a hospital. Right now, even if there were all kinds of red flags and indicators, things in their history, all kinds of things that should have, could have told their employer that they were at a very high risk or propensity to commit this kind of an act. We never get to find out about due diligence was done or any of those other things, because what the court's told us now is under these circumstances, the hospital can't be liable, so there's no point in doing any other discovery, fact-finding, or getting to any other issues about what happened. But what your bill would do is just say, hey, we're not going to determine necessarily that there was negligence or necessarily that the hospital did anything wrong, but we can at least inquire and find out if any of the other elements to establish a tort are. Am I understanding that right?
So the answer to that question is yes and no. So the answer is yes, that your case is dead on arrival with respect to vicarious liability. So vicarious liability is I'm going to impose liability regardless of the company's independent fault. So for instance, you know, let's say I have a delivery business and I have all kinds of policies about drive safe, you know, don't drive too close and you need to brake and do everything else. And then somebody doesn't and oopsies runs into the back of someone. The company's vicariously liable, even though they've done everything right. So that's one claim that now in these cases can't get. That's it. The other way in which the things that you discussed about background checks and everything else would be a direct cause of action, which you will sometimes get, which is negligent hiring, retention, things of that nature. So for instance, not doing a background check. That's a direct cause of action, like the employer committed the tort. I hope that makes sense.
Yep, it does. Okay. Right. Anybody else wishing to be, any questions for Mr. Dix or Delegate Delaney at this point?
Mr. Chairman. No.
Delegate Kilgore, and then Delegate Thomas.
Just a question. I'm just read the statute. Does it doesn't appear to require a conviction of sexual assault?
That's correct.
Why? Can you walk me through that decision?
Certainly, for a couple reasons. One reason why that was included is we wanted to make it very clear that we are not importing a standard of beyond a reasonable doubt into a civil finding statute, number one. Number two is that if you made it contingent upon a conviction, then it's almost backwards. It's saying that the more egregious it is, the more outside, the more criminal it is, the more likely it should be in there. That's kind of backwards. But the last is the most important part, which is there's going to be no coverage. I mean, the insurance company is going to be like, you don't have any coverage. Now, if the Chamber of Commerce wants to agree that in exchange for a conviction, they'll indemnify all of the defendants, maybe, we have something to talk about. But that's not going to happen. What they're going to say is this person committed a felony, there's no coverage, and by the way, company, we get to take a walk. That's what the current law is.
All right, Delegate Thomas, and then Delegate Ballard.
Thank you, Mr. Chairman. This question might be from Mr. Dix or counsel, whoever can adequately answer. Where does the Virginia Supreme Court's ruling currently put us among other states on these issues? And then, if passed, where would your law bring us among other states with this different regime?
Mr. Chairman, Delegate Thomas, candidly, I haven't done a survey in a very long time since I started authoring that law review article, which I sent around to the committee members. They're all over the place. In more conservative southern states, there's no liability. Some of the northern, more liberal states, there's the kind of liability that we're talking about. So unfortunately, I can't give you a good plot of exactly where we would be amongst all the others. However, we would not be the only state that can hold people responsible for intentional torts. Moreover, the law was trending in the right direction. I mean, as lately as a few years before this 2018 trilogy started, it was closing in more and more to be almost the same inquiry as negligence, which is, for lack of a better term, you're on the clock, but you're not on a frolic or detour, you're responsible. That's the way the law was trending until 2018 hit.
Delegate Ballard.
Thank you, Mr. Chairman. Mr. Dix, let me make sure I understand. So this is only dealing with the intentional tort of sexual assault, no other intentional tort, correct?
Mr. Chairman, Delegate Ballard, that's correct, because the second and third decision of the trilogy were squarely sexual assault, and we wanted to keep it limited to the most egregious cases.
And then, Mr. Chairman, just a brief follow-up. To kind of piggyback on what Delegate Kilgore was saying, and you mentioned in your comments, so this is not creating some type of strict liability. A plaintiff would still have to prove your typical duty breach causation damages, and part of that calculation, I'm assuming, is whether or not the sexual assault occurred just by a preponderance of the evidence, not as in a criminal situation where it's beyond a reasonable doubt. Am I understanding that correctly?
That is correct, yes.
Thank you, sir.
All right. All right, is there anybody in the audience wishing to speak, anyone else in the audience wishing to speak in favor of the bill? All right, those opposed to the bill. Are you in favor or opposed? Oh, I have some questions. Okay, well, why don't we hear from folks that are, why don't you come on up and identify yourself and who you're with, and maybe we'll see if we can help get some answers to some of your questions.
Hi, I'm Megan Wagner. I'm an attorney in Virginia, and I am on the legislative committee for the Virginia Defense Attorneys. And so we have some questions about the way the bill would operate in terms of, how it would play out for us to navigate the way it
Gotcha.
goes.
So I'll put you in the category of concerned, leaning towards maybe opposed, but with questions that might be able to satisfy your concerns.
Yes.
All right, why don't we hear a little bit about what you'd like to know and see what we can do with that.
So we're being told that this is not a strict liability situation, but where the language says that the employer or agent shall be deemed, where the act shall be deemed to have occurred within the course and scope of employment, I think that to us reads like strict liability. And I'm wondering why the language is shall be deemed as opposed to a rebuttable presumption type of standard to allow, evidence from both sides on whether or not it actually arose in the course and scope of employment. So that's one of our questions. And then going back to the language of the act where it says employer or principal, I think we want to know what's the difference between a principal and an employer. Would this be like subcontractors, or, you know, sort of how far does this flow away from like a normal sort of employer-employee relationship? And then in regards to the language, who's an employee or an agent, our questions would be like, would an agent be subcontractor? So if you have like a large corporation and you're hiring subcontractors and you have no way to vet those people, you know, how would you be able to prevent these types of situations if you don't have the control situation in place? So those are some of the questions that we have.
All right. Mr. Dix, you want to take a stab at those?
Okay, I will, Mr. Chairman, I'll do the best to answer the questions that were raised. With respect to the first question about strict liability and why is it not strict liability? Well, the answer is that this is a bill that would create a finding instruction. So the jury is going to be instructed, for instance, ladies and gentlemen, jury, you are instructed that you shall find that companies that the act of the assailant occurred within the course and scope if you find the following, but for, and the act occurred on such and such. And that's where the importance of subsection B is. The jury decides. The jury doesn't have to decide this. They can say, you know what, I didn't think there was but for. So the fact that it says but for and that if and that goes to a jury and everything else, it would have been a lot easier if it had just said, you know, you shall find for the defendant, for the plaintiff if such and such. So I think the structure of this makes that clear. Difference between principal and employer, I mean, it's in the law. You know, an employer is someone who hires someone. A principal is someone who engages an agent to go out. Back in the old days, we used to call it master and servant, and that's fallen into disfavor, and that encompasses everything. But we figured that by saying employer and principal, with all due respect to Mr. Mullen, that maybe will capture some people who were not employees but were agents, you know, then capture them as well. So that's what those terms mean.
You're right. So employer is essentially shorthand, real quick shorthand, W-2 employees and principal for 1099.
1099s, there you go. As always, Mr. Chairman said it a lot more eloquently than I did. And then the last part about the control function and, well, what about if we try to exercise control? Well, that's why we have the tort system, right? It's about incentives. The tort law, as a matter of public policy, is about two things. It's about compensating a victim, but it's also about incentivizing or disincentivizing certain behaviors. And in these kind of situations, who bore the risk better? I've been in a hospital. They didn't come in and give me a book of a bunch of nurses and say, Mark, who do you like best? Well, I don't know. Let me see their background checks. You know, oh, well, that one looks pretty good. I don't get that choice. They send them in. They give them credentials. They have access to, you know, me in a pretty intimate way. It's on them. The risk is borne by them. And when things go wrong, they bear the cost, not the victims.
Gotcha. Thank you. And it's again, just looking at this, the Supreme Court has a two-part test that they've developed over these last three decisions. The statute would say, by statute, we're going to have our own two-part test, with part two having some three little subparts. But essentially, we're substituting a different two-part test. But it's not a conclusion. It's just the test that needs to be applied. And then the other thing we're doing is saying, because we've the Supreme Court saying that the judge should find as a matter of law what these elements are. We're saying, no, these are actually questions of fact that need to go to the fact finder.
100%, Mr. Chairman. Correct.
All right. Anybody else wishing to speak? So anybody, now we've gone through the pros, the neutrals. Is there anybody here in opposition to the bill? Come forward.
Good afternoon, Mr. Chairman, members of the committee. Emily Webb with the Virginia Chamber of Commerce. First, I would like to thank Delegate Delaney for meeting with us this afternoon to talk more about this legislation. And while we do commend her on this initiative, this legislation would have significant negative impacts on Virginia's business community and our legal climate. This legislation places an undue burden on employers by holding them liable for criminal actions of employees or agents, even when such actions may be entirely outside of the employer's knowledge or control. It does significantly broaden the scope of vicarious liability, creating a precedent that employers are automatically responsible for crimes simply because of the employment relationship. As currently drafted, it allows cases to proceed regardless of whether the employee is charged or convicted in a criminal offense, and creates a situation where employers may face lawsuits based on unsubstantiated allegations. A preponderance of evidence standards means businesses could lose the lawsuit even with minimal proof, further incentivizing settlements and driving up costs. The legislation may inadvertently incentivize frivolous lawsuits against businesses, as plaintiffs do not need a criminal charge or a conviction to pursue these claims. As currently drafted, there are no safeguards for employers who take reasonable steps to prevent criminal behavior, such as background checks, training, or oversight. Even businesses that implement robust policies to ensure workplace safety and ethical conduct would face such liability under this law. And for these reasons, we do oppose the legislation.
Thank you.
Good afternoon, Mr. Chairman, members of the subcommittee. Tommy Herbert with the Virginia Restaurant, Lodging, and Travel Association. We would simply associate ourselves with the comments from the Virginia Chamber and asking you to oppose. Thank you.
Thank you.
Mr. Chair, members of the committee, I'm Brent Rawlings of the Virginia Hospital and Healthcare Association. I want to start by apologizing to the delegate for not having a chance to meet with her earlier today, but we are opposed to the legislation for the reasons that have been stated. I'm not prepared for this law school exam today. I'm not prepared for this trial. Mr. Dix, I can't challenge him on that, but I do just a few things I want to point out. And I will, act a little bit like a law school professor. This is a matter of bad facts. Bad cases can make bad law, and I think that's the path we're headed down here. Vicarious liability is common law. It's a common law doctrine that is fundamental in our Commonwealth, has been for a long time, and here with the stroke of a pen, we're going to just vacate all of that. Understand there's frustration with the courts and the judges, but this is a matter that should be resolved in the courts and through jurisprudence. So that's the kind of the first kind of opening remark here with this. The other thing, we're hearing that this is not a strict liability law. It may not be strict liability as written, but in practical effect it would be. And if you just take a look, the shall be deemed language is there, but just look at the test. We've heard that none of the elements would be taken away from this, but we talked about but for the employment. That was described as causation. So basically, but for, that just means you hired that person. That box is checked. So that's the first of two elements. Second element, the act or injury occurred, and you have an option here, three options, and this is or, but the first one being while on any premises owned or operated by the employer or principal. So that could be anywhere on the grounds. That could be in a secured parking lot. It could be in the parking lot. Also, to point out in this situation, that could be even if the employee is off duty. It doesn't say anything about that here. We keep inciting hospitals in this conversation, so let's take a hospital. It's a 24/7 operation. It's a big campus. Think about VCU. Think about controlling that environment and everything that happens with anybody that might be under your employment, simply by the fact that you hired him. We also had a conversation about red flags. Everybody does a background check for every employee in the hospital. That is something that we do very diligently. These background checks are extensive. When those flags arise, we figure out what to do. We hire or don't hire that person. Oftentimes do not hire that person. But this doesn't take into account the reality that people act in their own volition, even if they haven't acted that way in the past, making us strictly liable as a practical effect. We talked about victims needing just compensation. Can't argue with that at all. Absolutely, those individuals deserve just compensation. Typically, that just compensation would come from the assailant. In this case, the assailant does not have the funds to pay for the verdicts that will come from these cases. That will all fall on the employer, whether it's a hospital or any other employer. So we're very concerned about this legislation, the direction that it's headed in, and again, just voice our opposition. Thank you.
Thank you. All right. Any other questions for Delegate Delaney or any of the witnesses from members of the subcommittee?
Mr. Chairman, I actually have a question for the last speaker.
Delegate Thomas.
Not to drill down on maybe not being prepared for the exam, but I'm still trying to fully grasp I understand the criticisms of this proposed new test, but what I heard and have read about the current test seems really tough to meet. Could you give an example at a hospital, perhaps, of a fact pattern that would meet the current test? Because it sounds like no scenario would. So it'd be great to know if you could just give an example of what would meet the current test.
I can't give an example under the cases that have come out. I know there have been 5 or 7 cases that have, kind of dealt with this issue. I've not studied those closely. I think the reality is that there have been examples of hospitals that have been found vicariously liable in the past. So I understand that there have been some recent cases that haven't gone the way that folks would like them to, but it's not a legal impossibility that they would be found liable. And I'm happy to follow up with you or any members of the committee with some further information on that.
Thank you, Mr. Chairman.
Thank you. All right. And again, this bill is specific to the issue of criminal sexual assault. So with that, is there a motion?
Motion to report.
It's been moved and seconded that the bill report. Dr. Ballard, did you want to speak to the motion? I know I cut you off a little bit.
I was just going to briefly speak to the bill, but that's fine, Mr. Chairman.
No, we have a motion in a second, but we can
thank
speak
you.
to the motion at this point.
That's fine, Mr. Chairman. So speaking to the motion, I mean, just a comment. I understand the concern from the hospitals in those situations. I mean, when I read the current state of the law, I'm really concerned that the Supreme Court decisions took this away from the province of the jury. So that would be my biggest concern of why I like this bill. On the other hand, I am also a little concerned this may be somewhat too broad. And so certainly would like to have the conversation with the trial lawyers as well with folks on the other side. I'm going to vote yes for it now, but I do have some concerns that hopefully we can chat about before it goes to full or even to the floor. Thank you, Mr. Chairman.
Thank you, Delegate Ballard. All right, Delegate Leftwich, speaking to the motion.
I'm going to associate my comments with Delegate Ballard, but I'm going to vote the other way. But we're thinking just alike.
This is sort of the flag so it doesn't get too fast a track and sail out of here without enough extra review, is what I hear you saying. All right, so with that, the clerk will open the roll on the motion to report. The clerk will close the roll, and the bill reports 7-1, but we may be able to get 100% unanimous with a little extra tweaking, Delegate Delaney.
We'll get there. Thank you, Mr. Chair. Thank you, committee.
All right, thank you, everyone, and I believe that concludes our docket for today. I will get with Ms. Olwine, and we'll docket some things for Wednesday as well, so be on the lookout. But with that, the committee is adjourned.